IMD Corporate's podcast. I am Adriana Balmus, joined once again by Olexandr Kyrychenko, partner with IMD Corporate and an expert in corporate and commercial law. Hello, Olexandr.
Hello, Adriana. Thank you.
In the last episode, we discussed the different business structures that you could consider when establishing your business. In this episode, we will focus on the essential legal documents that you must have in place. It is important to bear in mind that this is by no means a comprehensive list.
Yes, that is correct, Adriana. Also, we'll discuss the fundamental corporate documents that you will need in a limited company. You should seek legal advice to ensure that all the pieces are in place at the outset of your business venture. So where I'd like to start is the Articles of Association. Now, the Articles of Association is perhaps the most important corporate document. This is because every limited company must have adopted Articles of Association. These act as the company's de facto constitution and a governing document. Now, the company may, on its incorporation, adopt what is known as model articles. Now, these are essentially articles which are accepted to the Companies Act. And these contain standard governance provisions. However, model articles may not always be suitable, with a good example being the lack of provisions dealing with different rights as may be attributed to different shares, a lack of pre-emption rights to existing shareholders and share transfers, and no specific director appointment rights, amongst others. This often means that bespoke articles are adopted on incorporation, or amended model articles need to be adopted. Now, you may establish a company with model articles and then wish to adopt new articles, and that is absolutely fine as your business develops. Now, acting as the company's key governing document, the articles will contain provisions as to how directors and shareholders are permitted to make decisions. They will include procedures for issuing shares, procedures for transfer and transmission of shares, and will contain a host of other director and shareholder rights and protections. As I mentioned, it is a legal requirement for each company to have Articles of Association. And when no articles are adopted on registration, Companies House will automatically assign model articles to the company. It is, however, unlikely that model articles will be suitable for a business with 2 or more individuals, and in particular for investors. For example, model articles do not require any outgoing shareholders to offer their shares to the remaining shareholders before selling them to third parties, what is known as pre-emption rights, nor do such pre-emption rights exist automatically under the Companies Act, which would make it very unattractive to any investor and indeed to many business partners, as they may not wish to end up in business with a third party. For investors in particular, model articles do not provide for any minority control provisions or rights to appoint your own directors, nor do they contain special rules in respect of different classes of shares. It is therefore advisable to consider short or medium goals, as well as the protections that you seek at the outset, to ensure that the relevant rights, obligations, and protections are enshrined in the 2 articles when incorporating a business.
Are there any other corporate documents that you would recommend are in place from the outset?
Well, yes, there are. Then in particular, where a business has more than one shareholder, it is critical, in my view, for shareholders to enter into a Shareholders Agreement, otherwise known as a Founders Agreement. Now, a Shareholders Agreement is essentially a contractual document which will outline the rights and responsibilities of each shareholder of the company. And these will include various minority rights, and what happens when things go wrong, or when one of the shareholders works against the interest of the company by, for example, setting up a competing business, or critically, where there's a disagreement in the running of the business. Now, each shareholder will be bound by the terms of the shareholders agreement, and where a breach occurs, this will allow the other shareholders, or any of them, to sue the shareholder in breach, seeking a variety of remedies, ranging from specific faults to damages, which the aggrieved party has suffered. Now, unlike the constitution of the company, this document is intended to govern a relationship between the shareholders themselves and the way that they govern the company as between themselves. And whilst there will be some overlap with the articles, unlike the articles, this document does not need to be filed with Companies House and can remain confidential. In addition, any incoming shareholder will be required to sign a deed of adherence to the existing shareholders agreement unless a new one is negotiated, and will therefore be bound by its terms. Now, whilst there is no legal requirement for a shareholders agreement, there are some substantial risks if one is not in place. One of the biggest risks establishing a company without a shareholders agreement in place is there being a disagreement between the parties which they cannot move past. And this is particularly troublesome in a 50-50 shareholder. Now, this is because where such disagreement arises, this could effectively paralyze the company. Now, Companies Act, when company law generally, barring a petition to the courts, which is costly, expensive, and unpredictable, does not provide for a resolution mechanism in such scenarios. And this can have devastating consequences for any business, in particular a new business. Shareholders agreements can contain compulsory resolution provisions dealing specifically with such situations, otherwise known as deadlock. Now, typical provisions involve the purchase of the shares by one shareholder from the other for the highest price. However, there are a number of different mechanisms that can be put in place. Now, an additional risk is that a delinquent shareholder could actively undermine the business by, for example, setting competing business. Once again, say for petitioning the court, in particular their shareholder is not also a director, there would be no way to remove the shareholder from the business. And this is, once again, where the shareholders agreement can come into play, as specific bad legal provisions could be implemented therein. It is therefore, in my view, critical.
What about other fundamental legal documents that the new LTD should have in place when being established?
Okay, well, this will depend on the specific company, which may be subject to its own regulatory requirements in its specific industry. However, there are a number of commonalities running through. And one of the particular commonalities is that all companies will handle personal data at some point, and mostly right at the outset. And this will be personal data of whether it's employees or customers. Compliance with the UK GDPR, or data protection regulations, is therefore critical. And the first step to ensure compliance is that any business will need to make sure that it has GDPR compliant policies in place. Now, these policies will outline how the company will comply with UK GDPR and the Data Protection Act, and how they will inform the data subjects whose personal data the company will handle of their rights, which are set out in UK GDPR, and how they will deal with the data subjects' purported exercise of their rights. Which brings me to the internal documents that the company must have in place as to UK GDPR. And once again, as well as having those external policies, such as the privacy policy in place, there's also critical to ensure that those internal unpublished policies are in place and adhered to ensure that the company complies with the requirements in practice. Now, this could be whether when handling personal data or indeed when handling requests or data subjects looking to exercise their rights in respect to their personal data. Whilst these internal policies are not always documented, any non-compliance with UK GDPR can lead to substantial fines and significant damage to companies' reputation. In addition, it is a legal requirement for every company to have at least one director. And whilst we will discuss employment contracts in a future podcast, I would like to discuss a director service agreement briefly now. Now, the director service agreement is a critical document for UK companies, as it establishes full terms between the company and its directors. This agreement outlines the roles, responsibilities, remuneration, confidentiality obligations, and grounds for termination of the directors. Now, this can be a director, shareholder, or a third-party director that's been appointed. Legally, director service agreements ensure compliance with the Companies Act and set clear expectations, which can prevent disputes between the company and its directors, and could be further imported when we come to discuss employment law. The importance of the director service agreement lies in its ability to protect both the company and the director by clearly defining the scopes and duties and performance standards, which can be essential for regulatory compliance, business continuity, and effective governance. Without a director service agreement, there's a risk of ambiguity around the director's role, potential for breaches of fiduciary duties, and lack of enforceable protections for the company, its assets, and its confidential information. Absence of this agreement can also lead to an increased risk of legal disputes and higher liability for both parties. A director service agreement mitigates these risks, and in my view is quite critical, although not legally obligatory. Now, there are some other documents which the company should have on its incorporation. However, we will discuss them in a bit more detail in a future podcast on regulatory compliance.
Does this include all of the documents?
Well, no. I have mentioned just their most critical corporate documents, or documents which I believe will be critical from the day one of the company's existence. In reality, there will be a number of other regulatory and compliance documents that the company will need to have in place. And that's something that we can discuss in the future podcast.
Thank you, Olexandr. That wraps up today's discussion on essential legal documents. This episode made us aware of the importance of building a strong legal framework from the start. In our next sessions, we'll discuss about regulatory compliance across various industries, exploring how specific regulation can impact your business strategy. Thank you for watching us. Please don't forget to follow our social media channels and our websites for the latest insights. And see you next time.